Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, a podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's program is What are best practices for virtual litigation? Notes from the field. In these pandemic times in which we've been living for some time, the nature of litigation has changed. In the past, when they have tried to do virtual litigation, conferences by phone and video conference, it has been with a great deal of struggle. And likewise, depositions and other common litigation processes really were hampered when everybody wasn't in the same room. Well, we've been forced to learn a new way. And today we're going to talk to an expert who has been thinking about what are the best practices? How do you survive in a virtual litigation world? Our co-host today is Alicia Downey. Hi, Alicia.
Hi, John.
Alicia, what are we doing today?
Well, today we're fortunate to have as our guest Lisa Wood, who is the author of a long-running Notes from the Field column in Antitrust Magazine, which is the section's regularly published magazine. Lisa is an antitrust lawyer and co-chair of the litigation department at Foley, Hoag. She practices both in Boston and New York and elsewhere. Her latest article outlines best practices for virtual litigation. She will tell us about the research that she did to write the article, which included interviews with lawyers and judges from around the country. And as a special gift to the world, Lisa's article is available for download from the episode webpage at ourcuriousamalgam.com. So welcome, Lisa.
Thanks. I'm delighted to be here.
How long have you been writing the Notes from the Field column?
It was great that you asked that question because I'd sort of lost sight of it. It has actually been 15 years. I started writing the column in 2005, if you can believe that. And I had served on the magazine for about 3 years before that, writing general articles. And I was reminded when looking back that I wrote an article called In Praise of Norr Pennington, which provoked an immediate response from the then chair of the FTC, who penned an opposing article. So that was my exciting debut for the magazine. And from then, I moved to writing the column.
Now, the latest article, as we mentioned, looks at best practices for virtual litigation. Now, what do you mean by that term?
Well, I purposely kept the phrase broad and flexible, because we've all had to be flexible in these times. And what people are willing to do virtually keeps expanding and changing. I interviewed judges and lawyers last summer in early fall to write the column. And at that point, people were regularly handling mediations virtually, depositions, witness prep, testimony in a government investigation, hearings, appellate arguments, status conferences, and even evidentiary hearings and trials virtually. And so I included all of those types of proceedings in the column and in my interviews for my sources.
Now, you also regularly practice in courts and before various agencies. And how would you describe the role that virtual litigation has been playing in your own practice over the past year as compared to previous years?
I've seen a dramatic change, by virtue of necessity. I was working this past summer on a rather intense government investigation. And in the early days of the pandemic, many government agencies were not sure how long the pandemic would last and whether the agency would allow, quote unquote, virtual testimony to occur. But the investigation I was working on was priority enough that that particular agency decided to make it a test case. And it was the first case in which the government allowed virtual testimony. And so I spent the summer preparing witnesses I'd actually never met before I met with them and prepared them virtually, and then I represented them in testimony with all of us testifying or sitting from our own homes. And I was nervous about how this would go, but it went very well. And as a result of that experience, I've recommended to clients that virtual testimony and witness prep can play an important role even when we get to the other side of the pandemic. It's a great way to save costs, and in particular, when you need to draw in former employees from another part of the world, or other people that it just would be very hard to bring for multiple prep sessions in Washington, D.C., or to bring to a governmental agency in Washington, D.C. Virtual testimony can offer an opportunity to prepare someone without really interfering with their life very much, particularly if they've moved on and are no longer, working hard at the company that is in the investigation. I have done a number of status conferences virtually, and I think it's a great improvement over traveling all over the country to go to what could be a half an hour or could be a 2-hour virtual conference. I never really enjoyed conferences by telephone because I couldn't see the judge's face, and I really had no idea what he or she was thinking about what the lawyers were saying. So by video, you can pull everyone together without great expense and get a lot done in a short period of time. So I have recommended to judges, and I'm encouraged by judges' responses. They also like conducting status conferences by video conference, and they've told me in my interviews leading up to the column that is something they will continue to do after we get to the other side of this pandemic. And I think that's great because having regular conferences in large complex matters reduces the number of disputes, gives you multiple opportunities to educate the court about the complex issues in the case, and saves a lot of money for our clients.
Well, I agree with that. And so based on your experience and the research you did, without summarizing your entire article, which I do commend to people, I hope they will read the whole thing, let's pick 2 or 3 best practices for virtual litigation for lawyers, some of the do's and the don'ts.
Sure. So, what's extraordinary about the last 9 months or so, 10 months, however you want to define it, is that lawyers and judges have had to get together and innovate, which is great. But that means that there are no rules. There's no protocol that's set down anywhere on virtual litigation. So I think it's imperative that you reach an agreement with opposing counsel and with the court about what the rules of the road are going to be for the proceeding. And the article goes into all the details you should think through. But it's really important because we don't have a rule book to refer to for this. Another important best practice is to be prepared, which I'm going to sound like somebody's mother by saying that, but because obviously being prepared is always important for litigation. But in my experience, conducting a deposition virtually or conducting a hearing virtually, you need to just think through all the elements of it so that you don't have any stumbles. It will decrease your effectiveness if you don't think that through. And another best practice is really to invest in your technology. The judges all talked about this. They thought it was so funny that lawyers come to court with elegant clothing and fancy briefcases, but many have appeared in virtual hearings without good technology. And that's irritating to the judges because they can't see or hear you well. And that, of course, is going to reduce your effectiveness. So, and the last best practice that I will mention, because this is something I have really struggled with and still have to practice, you need to look at the camera. When all of us are on a video conference, it is human nature to look at the picture of the people you're addressing. But if you do that, you are not looking at the court. You are looking to the side. And it really affects the credibility of your presentation.
Well, and you could write another whole article about the etiquette of live virtual proceedings and how you could politely scream at somebody to either unmute or mute or get rid of that darned echo that I know we've all experienced. So yeah. There's an idea for the next column. This is the Antitrust Sections podcast, so I'd be remiss if I didn't ask you, is there anything about antitrust litigation or proceedings that you think is particularly well suited or not to virtual proceedings?
Great question, Alicia. So because antitrust cases tend to be complex and involve multiple parties, we are all well served by having regular conferences with the court. And I am very passionate about status conferences and the importance of them and active case management. And if the court can use virtual technology to hold routine conferences with the lawyers in the case without great expense, I think we will all benefit. And antitrust, and other complex cases really benefit from active case management. So that's one thing that I would call out. We also, in antitrust cases, have more motions, dispositive and class certification and Daubert issues than maybe some cases. And again, those types of motions can be addressed with virtual proceedings in a way that's efficient and ties up less time of lawyers and the court. And the other thing that I wrote a separate column about translation protocols. As our economy has become global, our antitrust cases often involve witnesses and parties from all over the world speaking different languages. So in addition to having a good handle on the challenge of translation and interpretation, virtual litigation offers us the opportunity to bring witnesses in virtually without having to bring witnesses in traveling several time zones. So because it's pretty common in every antitrust case to have at least some witnesses, if not many, that are traveling from far away or that might not be available. So I think those are ways in which antitrust cases are particularly well suited to having at least parts of the proceedings conducted virtually.
Yeah, that's a good practical point about the ease of scheduling, too. You don't need to accommodate 1 or 2 days of travel. Somebody can just turn their computer on, appear, turn it off without going anywhere.
Yep.
That should be very helpful. Now, you had mentioned that you spoke with judges who were very enthusiastic about virtual status conferences. Were there some other types of litigation activities that you think that judges are ready to embrace permanently?
Yes. So that was a question I asked every judge I talked to and every regulator that I talked to. What are you going to do on the other side? I think partly it's because I'm interested in focusing on when we get to the other side of this. But so in addition to status conferences, motion hearings, many judges said they would now hold those routinely, virtually, rather than in person. Many judges that I interviewed said that they would be open to hybrid proceedings, where you hold some testimony in court when it's safe again and some testimony remotely. Every judge has gone through the frustration of scheduling a trial and then finding that some important witness, can't get there on the date that it fits with the schedule. And virtual technology would help solve some of the scheduling problems and taking evidence out of order. And as we talked about before, bringing in testimony from witnesses that would have to travel a long way, maybe to testify for a half an hour. So I didn't talk to a single judge who was reluctant to have some witnesses testify virtually. And most thought that would be a real improvement.
Now, how about the lawyers you spoke to? I mean, do they agree with the judges, or is there sort of the traditional trial lawyer mentality of wanting to be in the courtroom, look the jury in the eye, make sure the witnesses are there in 3D? What's prevailing in their minds?
So I didn't interview anyone who conducted a jury trial remotely. I'm actually working on that topic as we speak. And I think it'll get published. That column will get finished and published this summer. There haven't been that many federal jury trials conducted remotely. A few states have held many trials remotely, jury trials. So, I interviewed one lawyer who began a jury trial in person, and then with the plaintiffs presenting their whole case, and then the court had to shut down, and the court wanted the defendant to put in their whole case remotely. And for obvious reasons, counsel didn't think that was fair, that one party would meet the jury face to face and the other party would have to do everything remotely. So I would say in general, lawyers have been pretty reluctant to conduct jury proceedings remotely. But every lawyer that I interviewed about trials, bench trials, said that it went much better than they expected, and they liked it quite a bit. One thing that is really nice about a virtual trial that you can't have when you're in the courtroom is you can confer with your whole trial team, with the client, with witnesses outside of the view of the court or the jury. Of course, we all need to communicate with clients and our trial team during a trial, but in my experience, when you're in the courtroom with a jury sitting there, or even just in a bench trial, people are passing you little notes or they're whispering in your ear, and it's very distracting both to the trial lawyer and to the fact finder. So the behind the scenes way you can communicate in a virtual proceeding has some real benefits. And I'm not talking about inappropriate communications with a witness. I'm just talking about the inevitable talking to the lawyers on your team, getting feedback from the client on how they think things are going. And the column goes into great detail about how different trial teams have worked that out and what technology they've used to communicate. I think in general, and this should not be surprising, lawyers who have not yet tried a virtual trial or a virtual proceeding are reluctant and believe that it will be unsatisfactory. But lawyers who have done it have enjoyed it. So like all new things, we're going to need to get some practice to get more comfortable. I've been surprised. I've represented a few witnesses who have been very effectively cross-examined virtually. I think people's instincts were that would be hard to do unless you were in person with a witness. But it's actually worked pretty well. And then I interviewed some people about conducting internal investigations remotely. And the lawyers that did that I interviewed said that actually they found that witnesses would talk to them longer and opened up more than if you had brought them into a conference room, at the company's facility. So that was sort of interesting too. So I think there are aspects of this that we're going to continue to learn our benefits that we haven't yet figured out.
You're putting the finger on a good point. There really is something very frightening to non-lawyers who do not normally frequent courtrooms, to even in a civil case, even if they're not the party being sued, to walking into a courtroom, taking a witness stand, being sworn in, looking in a giant courtroom. It's a very unfamiliar environment.
Yes.
The contrast, though, with being essentially questioned, but while they're in the comfort of their own home, if it's your witness on direct, I can see the advantages, but I can also see the advantages if you're cross-examining somebody because they'll just relax and start talking.
Yeah. There's an intimacy that I like for talking to judges and that I like for talking to witnesses. And then I was going to mention I had the fascinating conversation with a jury consultant that's worked with 2 state court systems about setting up virtual jury trials. And I haven't read their research, the underlying research, but I've read the results. And what they have found when comparing the experience of jurors in socially distanced trials, which are probably scary and not ideal, but comparing that experience with being a juror in a virtual trial, the jurors were more engaged in the virtual trial and liked it much more, which is counterintuitive. And, most of us are concerned that if jurors are sitting on their computer at home listening to a trial, we're going to lose them. But the research of these jury consultants using actual mock juries in several proceedings was that the jurors were more engaged virtually. So, there's more work that has to be done, and we're going to have to feel our way through that. And there are some legal issues that need to be worked out, and I don't pretend to try to address those in my column. I'm really focusing on the practical issues, but criminal proceedings virtually, and the right to confront witnesses, I'm not sure how we're going to work that all out. But in the process of just doing what we can to make progress in cases during this pandemic, I think we're learning a lot that we'll keep when we get to the other side.
Well, that's great. And I want to thank you, too, for writing your article, because I think it brings together really the latest ideas for best practices. And it's just great to have them all in one place. So again, anybody who wants to read Lisa's article and her other articles for Antitrust Magazine should go to the section website and check them both out.
Lisa, it's interesting that we often talk about what's the good that's going to come out of this pandemic. And the optimist in me says, hopefully we can get to a world where we take the best of the best and that everything kind of becomes, you talked about something becoming a hybrid almost every, so why can't everything become a hybrid, right?
Right. Exactly. No, I think there's real promise in this. And I want to put a plug in because I did mention that I'm working on a column on virtual jury trials. And if anyone listens to this podcast and has passionate views on the subject and has had any experience, I'm always looking for new people to interview. So just send me an email and I'll follow up.
So I'll share my experience, which is not about a jury trial. Many of us who practice in the antitrust world and the consumer protection world as well, our practices are not confined to one district. So, I live on the East Coast. I have cases in California, and I cannot tell you how many times I've had to go out for a 15-minute conference to a city in California, which becomes a 2-day endeavor, 12, 13 hours on the plane. And, for 15 minutes, where oftentimes I'm in a group and I'm not even the lawyer that's doing the advocacy, but I can't not show up because what happens if I don't? Right. And the virtual conferences, I think, are really going to improve our lives. I did one recently in those circumstances, and it was truly a 15-minute experience. The judge checked in. He figured out, he heard what he needed to hear about what was going on in the case. He was satisfied with the status. People asked their questions, and we were done. And I was on a call 15 minutes later. So hopefully we could take the best of the best and maybe a little good of that will come out of this.
Even, I too handle, that's a good point about most antitrust and consumer protection lawyers have a specialty that has them handling cases all over the country. And, but even if I'm confined to one of my home cities, taking the subway, waiting in line in the security line, sitting with all the other lawyers who are waiting for their case to be called, it could be 3 or 4 hours of downtime before my moment in the sun. So there are many opportunities here for efficiency.
And just to contrast it, I was involved in a case that started a couple of years ago. Early on in the case, again, it was in California. Early on in the case, the judge said, "You know what? Counsel from out of town, you don't have to show up. We'll put you on the phone. It's no big deal." And let me tell you, that went absolutely horribly because we were, there was somebody from the group that was in the courtroom, and thank God, because the dynamics just didn't work. The technology didn't work. We have figured that out, I think.
Yes.
Clients are going to be happy too. What a huge save.
Yeah.
The other thing that's interesting is, we'll do what's necessary, fly across the country for the 15-minute hearing if we assess that it's important. But clients, busy executives often can't just drop everything for 2 days to sit around and wait for their case to be called. But they can definitely dial in to a Zoom call. So the other thing that I really think is great and that I hadn't mentioned before is there's greater client participation. And then there was an article just a couple of months ago, Judge, and this didn't come up in my interviews, but I've been sort of keeping up in the reading. There is greater participation now at any hearing about the fairness of a class action settlement or about a proposed class certification. And the members of the class, who are in theory supposed to be participating in these proceedings can now very easily participate. And so it makes more meaningful the process of notice and hearing and approval because those being affected can actually participate.
Lisa, remember when we used to tell young associates, go down to court and just observe arguments for a day?
Right.
We can tell them log in for an hour,
right. Exactly.
and they can get that experience much more efficiently.
Yeah, but we used to walk uphill in the snow.
Both ways.
Yeah.
Right.
Well, look, Lisa, this has been really helpful for our folks. Let me shift gears just a little bit.
Okay.
What advice do you have for younger lawyers that want to do what you do?
So I have always thought although obviously doing antitrust work is a specialty, I have always thought that trying to get a broad range of experience improves my skills as a trial lawyer. So to the extent you have the opportunity through pro bono and in your early years as an associate to work on a lot of different matters and talk to clients in a lot of different industries, I really think it serves you well, because when you go then as a more senior lawyer to sort of figure out what the case is about, what the trial theme should be, what's going to resonate with a jury or a judge or a regulator. If you have a broader experience, you have a better shot, I think, at being effective. So I am a big advocate for broad experience. I also went to a liberal arts college. I still would recommend that for the same reason. I just think if you bring more experience to bear, you're going to be more effective. And I think if you specialize too early and too narrowly, you have a real shot at missing the forest for the trees.
Yeah, and if I could plug pro bono for a second, my first deposition was of a prison guard. And that probably remains my most difficult deposition of all time, because trust me, that prison guard was not interested in opening up to me. But you're absolutely right. And that was clearly not an antitrust case. And it was a really good learning experience.
Yes.
All right.
Yeah. No, and I think, if you get, obviously, in that kind of case, you're going to get experience earlier. The stakes may or may not be as high, but for whatever reason, as a young associate, you're going to get more opportunities. But the other thing is and I know this is true of Alicia too, I both give advice pre-litigation and handle litigation. And I think that's made me a better trial lawyer, because I understand why businesses make the decisions they do, because I've helped them make those decisions. And I think it's great to have that variety of experience too.
And vice versa, right? Because when you're giving the advice, you're thinking about, how is it, if we ultimately get down the road, maybe client, you're on the right side here, but you're close to the line. If we ever get in front of a jury, boy, I wouldn't want to be you.
Exactly. Good point. Yeah.
Well, okay, let's shift gears again. Can you tell us something interesting about yourself that we wouldn't know if we only knew you professionally?
If we're going to go outside my professional experience, when I was in college, I had experience cooking and actually considered a career as a chef, and worked at several French restaurants as a sous chef. And I also, when in college, was able to design the vegetarian meal plan and actually become a cook in the dorm cafeteria area and cooked breakfast for 600 people. Now, I pretty quickly, after working in restaurants, realized that it was a really hard job. You never got any time off. And I have to say that it is much harder than being a lawyer. And we all know that we have demanding jobs. But every once in a while, that experience comes in handy in life.
Well, okay. So what's your go-to meal that if you want to kind of impress somebody and say, and serve the meal and say, in college, I was actually a sous chef. What is your go-to?
That's a great question. So I probably wasn't so much in college, but I married a man whose mother was from Sicily, and she was a fabulous Italian cook, and she taught me a lot of things. And so I would say that I have really learned to cook good Italian food, which would be surprising to most, because if you look at me, you would not guess that I'm Italian, because I'm not. So I love to cook lamb, and I do it quite well.
Are you familiar with the term mangia?
Yes.
Okay, then that story is true. You have indeed have an Italian mother-in-law.
She passed the test.
All right, let's go to our last segment, which we call the Curious Hat.
And now it's time for the Curious Hat.
When we are together in non-pandemic times, I have an actual hat, and in the actual hat is our actual questions, and our guest typically pulls the question out of a hat and then asks the question they pulled. Since we are not all together, we are doing this virtually. I have a list of questions in my right hand, and Lisa, I will ask you to choose a number from 1 to 25, and I will ask you the question that corresponds with that number.
Okay, I'm going to go with 8 for whatever.
Okay, question 8. Okay, what is your perfect weekend?
Oh, a great question. Perfect weekend. It would be in New York City with theater reservations on Friday and Saturday night and Sunday afternoon, with great restaurant reservations for dinner on Friday, late lunch on Saturday, and brunch on Sunday. There you go.
Where would you be going pre-theater?
Well, I never like to eat a big meal immediately before theater. I've discovered that that's not a very good way of ensuring that I'm fully engaged in the performance. So I'm really interested in new chefs, so I try to pick new places all the time and somebody trying something different. And of course, pre-pandemic, New York was full of interesting places with chefs trying new things. And the same with theater. I'll see Broadway, but I also love to go to places all over the city and see experimental stuff. So, and no repeats. I don't go to the same place twice. So, in terms of restaurants, so it has to be someplace I haven't been before.
So it's kind of like some people don't sleep in the same house twice ever. It's kind of the same way. You've never been to the same restaurant twice?
I will occasionally for convenience, but if I'm talking about a perfect weekend, it would all involve new restaurants, new experiences. Well researched, but new experiences, places I haven't been before.
Now, I probably should last question, and this is what I'm just struggling with a little bit. If you never go to the same restaurant twice, how do you know which one is your favorite?
I don't have a favorite.
There's the answer. Okay. Well, Lisa, thank you so much for joining us, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.